Let's keep on reading. Let's keep on reading. Without sufficient evidence that the district attorney acquired a personal stake in the prosecution or that her financial arrangements had any impact on the case, the defendant's claim of an actual conflict must be denied. The finding is of no. This finding this is important. This finding by no means is an indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing. Rather, it is an undersigned opinion that the Georgia law does not permit the finding of an actual conflict for simply making bad choices, even repeatedly. And it is the trial court's duty to confine itself to the relevant issues and applicable law properly brought before it. Once again, it's not really about whether we think is right or wrong. It's about, according to the law, conflict of interest means a very specific thing. The defendants did not show us a conflict of interest based on what we consider law. So we got to deny this motion. It is what it is. Now, I do think that this is important for the layman, for the civilian, for the person that's not professional law to understand that when he says Georgia law does not permit the finding of an actual conflict for simply making bad choices even repeatedly. That's not what conflict of interest means, my people, my good people. It doesn't mean that. And again, from day one, I've been saying, especially last week, Fani Willis's only mistake in this they couldn't find anything else. Her only mistake was choosing Nathan Wade to do this case, to prosecute this case. That's her only mistake. There's nothing else that they have on her. They have stuff now because all this financial issues. But as far as this case goes itself, the only mistake she made was dealing with Nathan Wade. That's a rhyme. And even that's not a conflict of interest. Again, they should have worded it. They should have worded their stuff better. That's on them. They should have figured that out. That's why you need sharks around. And the reason I brought up Harold Jones, and it's not to say that I think Judge McAfee saw what Harold Jones said and came to that conclusion. Harold Jones read the law the same way McAfee read the law. And they understood it the same way, which was, this is not a conflict of interest. It just is not. Not based on the cases that you presented and cited, not based on the evidence that you presented, not based on what conflict of interest means. It's just not, it just is not that. So let's keep on going. It's a lot here. Now, this was another big one that me and the gentleman were having a conversation with on Facebook about the appearance of impropriety, right? So this means pretty much you don't need to have a conflict of interest. You just need to have the appearance of impropriety, right? And again, this is another thing that is not law. There's no statutes to back this up. This is kind of just case law helps support, what we should do when we find an appearance of impropriety. While formally undefined in Georgia precedent, an appearance of impropriety is generally considered conduct or status that will lead a reasonable person to think that the actor is behaving or will be inclined to behave inappropriately or wrongfully. Now, what's important to note here, and that comes from the Black's Law Dictionary, that definition or that segment is cited. What's important to note here is that, what does it say here? Impropriety is generally considered conduct or status that will lead a reasonable person to think the actor is behaving or will be inclined to behave inappropriately. So that reasonable person part is important. So they put an excerpt, Judge McAfee put an excerpt after that to explain what a reasonable person is and what a reasonable person is not, right? Borrowing from federal judicial recusal standards, a reasonable person is not an uninformed member of the public with only a passing knowledge of the facts at hand. This must be the standard, as otherwise in a case, as a casual, uninformed, misinformed observer might believe the district attorney must recuse herself merely because her father shares a last name with the co-defendant. nor is it a reasonable person hypersensitive or unduly suspicious without an understanding of the relevant legal standards in judicial practice. So, pretty much saying that when they say reasonable, when they use the term reasonable in the court of law, it does not just mean somebody, some random person could question it. That's not what that means. Reasonable means you have the aptitude to understand what's going on, and you actually know some of the facts behind what's happening. Right? Once you know the facts, then you can give the proper. Once you know the facts and you've been paying attention to this whole thing, now you let us know what your opinion is. But if you're somebody that just never heard of Fani Willis, never heard of this whole thing, you know who Donald Trump is, but you don't really know what's going on, and you just said, hey, that lady has a conflict of interest because she's been messing with the prosecutor. Your word is disregarded in the law. They don't care what you think. You don't have enough information to be considered a reasonable person. Right? Being in the court of law, reasonable, there's a basis for reasonable. And it does not just mean an adult human. A reasonable person is a person who is educated on what's going on before they give an opinion on it. Okay. The appearance standard recognizes that even when no actual conflict exists, a perceived conflict in the reasonable eyes of the public threatens confidence in the legal system itself. So they're pretty much giving the background on why we must make action, because if a reasonable person views this as and they're not confident in the outcome because of whatever conflict or whatever appearance of conflict exists, then we have to change it, because that reasonable person does have enough information and it does look fishy. So let's just make a change. That's pretty much what you're saying there. Let's see. Now, so they're getting into it where they pretty much letting it be known like why they came to or why McAfee came to his decision to pretty much remove Wade and not Willis. So, when the appearance of a conflict exists, only the affected prosecutor, be the elected or appointed, is affected. So, let me. What was I about to read here? Yeah. Let me see. Did I have anything? So pretty much what they're saying is, hold up. Excuse me. Sorry, hold on. Give me a second. I'm sorry. Dismissal of indictment is extreme sanction. I'm not reading right now. Okay, here you go. Now, and I'm going to go back. Let me just go back up and read what I had first. My bad, y'all. So let's read this part here. Wade's patently unpersuasive explanation for the inaccurate interrogatories he submitted in his pending divorce indicates a willingness on his part to wrongfully conceal his relationship with the district attorney. Did that make sense? I chopped through that. Wade's patently unpersuasive explanation for the inaccurate interrogatories he submitted to his pending divorce indicates a willingness on his part to wrongfully conceal his relationship with the district attorney. As the case moves forward, reasonable members of the public could easily be left to wonder whether the financial exchanges have continued, resulting in some form of benefit to the district attorney, or even whether the romantic relationship has resumed. Put differently, an outsider could reasonably think that the district attorney is not exercising her independent professional judgment totally free of compromising influences. As long as Wade remains on the case, the unnecessary perception will persist. So it pretty much means one of them is not the problem. The issue is the combination of them in this case. So we got to get rid of one of them. And because Wade is the one that has been under oath lying already, he's the one we're getting rid of. That's pretty much what they're saying. And they pretty much, yeah. So let me keep on. Let's keep reading down here. Again, I told you it's 23 pages, so bear with me. Okay, so pretty much then they talked about, we have to get rid of him. And so then you have the forensic misconduct piece. And what they're calling forensic misconduct is Fani Willis going into public at that church back in January and telling everybody they are going after me because I put a black man in position. They had no complaints about the white man. The white man I appointed, who's also a good friend and a great lawyer, but they only have a complaint about the black man I put in place. Racist. Pretty much like, yo, they racist. They got an issue with black people. So the defense is like, this is, prejudice against us. This is pretty much defaming our character to the public and trying to sway the general public into thinking that we're all racist. And the judge said, nah, even though it's bad, it's not. Let me read exactly what they say. However, the speech did not specifically mention any defendant by name, although not improvised or inadvertent. It also did not address the merits of the indicted offenses in an effort to move the trial itself to the court of public opinion. Nor did it disclose sensitive or confidential evidence yet to be revealed or admitted at trial. In addition, the case is too far removed from jury selection to establish a permanent taint of the jury pool. As best it can divine, under the sole direction of Williams, the court cannot find this speech cross the line to the point where the defendants have been denied the opportunity for fundamentally fair trial, or that it requires the district attorney's disqualification. But it was still legally improper. Providing this type of public comment creates dangerous waters for the district attorney to wade further into. The time may well have arrived for an order preventing the state from mentioning the case in any public forum to prevent prejudice, pretrial publicity, but that is not the motion of this present. That is not the motion that's presently before the court. The defendant's motions demanding disqualification and dismissal based on forensic misconduct are denied. He was denying everything. Damn. They was cooked. Now, I did, I don't know if y'all paid attention to me back then, but I actually interviewed attorney Gerald Griggs. And this was years ago, so I've been following him ever since then. And Gerald Griggs is actually the president of the Atlanta chapter of the NAACP. He's also been friends with Fani Willis for over 25 years. He's also been friends with Nathan Wade for 16 years. So he's very close to the case. He actually was in court a few times while they were testifying and everything like that. So shout out to him. But he actually, after today's ruling, he went on CNN and discussed this whole thing. He discussed this part about the time where well arrived for an order preventing the state from mentioning the case in any public forum to prevent prejudicial pretrial publicity. So his assessment of it was, and he's also a lawyer, by the way, his assessment of it was that if they're going to prevent the state from speaking about this publicly, they need to prevent everybody involved from speaking publicly about it, because anybody can sway a jury pool once the jury's selected, or once the people who potentially will get selected as jury. Everybody involved in this has equal power, or maybe not equal power, but everybody has the ability to sway the general public. And if they're going to ban one side from speaking about it publicly, then all sides should be banned from speaking about it publicly.
I think my friend was opining on the decisions that are being made around this case. And I think she was also stating and pushing back on the attacks by politicians. I think the judge, if he's opining, issuing a gag order, the gag order should be on all parties, because it's not just the prosecutor's office that is talking. It's not just the defendants that are talking. It's not just the judge who is talking. So I think to avoid the appearance of any impropriety, if he's thinking about issuing a gag order, it should be against all parties so we can get to the actual disposition of this case in the four walls of a courtroom.
So, and I agree with him on that. I don't see why only the state would be denied. And maybe it would be punishment for them, or for the Fani Willis going out there and speaking about defendants in the public. But that's pretty much it. Man, this was a heavy one, man. This was a heavy one. I haven't seen anything like this before, honestly. But I mean, I think most of us haven't seen anything like this before. If we have, they would have come to this decision a lot sooner, because there would have been case law and all this other stuff, rules and statutes and all that for this. But there's not anything, because this is the first of its kind, essentially. So, y'all let me know what y'all think about that, man. I think that Fani Willis needs to lawyer up. And so I definitely think Fani Willis needs to lawyer up because they weren't able to take her down in this disqualification from a conflict of interest. However, that Senate hearing should scare her. They are interested now in all those financial documents, and if they start investigating or if they try to come with an indictment at the state level, they will for sure subpoena those bank records. She won't be able to get out of that. So, and they're gonna make her show us where you was getting show us where you was taking out $2,000 and $4,000 and giving this man that much money. Show us that. And also, you said under oath that you used $50,000 of your campaign money to do X whatever else, or however much she said. She said she used her campaign money to supplement some other expenses or whatever like that. So, according to them at that Senate hearing, they all know that that's illegal. So, again, you should get the best lawyers in the state. Do not work with Nathan Wade. Don't have him defend you. And definitely don't have Terrence Bradley defend you. They said Terrence Bradley was so stupid. They couldn't even regard anything he said as, it couldn't even be regarded. Like everything he said was just mumbo jumbo. And it's in here. It's in that ruling from the judge. It's like Terrence Bradley was just like ridiculous, pretty much. Just pretty much ridiculous.